Are we waiting for anyone else to come into the room? No? Well, ladies and gentlemen, welcome then to our fifth and last day of the hearing. This morning is going to be given over to the closing submissions of the claimant, including responses to questions of the tribunal. This afternoon will be given over to the closing submissions of the respondents. So, Mr. Copa, over to you.
Thank you, Mr. President and members of the tribunal. Let me say that in our opening, we indicated that it was an honor to address you with respect to this case, and the events of this week have not disappointed us. And so in my closing submissions, I will fundamentally urge you to apply the rule of law to the dispute between the parties. And in our submission, that application admits of no alternative but to grant the claimant's claims in an appropriate amount on the condition that they transfer title upon payment of the amount awarded by the tribunal as requested by the respondent. Now let me say a couple of things by way of introduction. And I thought you had already my slides, but you're now going to have the hard copy of the slides.
And I note simply that a copy has been passed to the interpreters already.
Now, just by way of introduction, let me say a few things, purely by way of oral submission. What have we learned this week? In my submission, in the most general of terms, in relation to the dispute between the parties, what we have learned is that the determination of the state of Costa Rica to take the claimant's properties and to defer and avoid, if at all possible, paying the value which is assured to them under the treaty and under customary international law continues to this day, and more state action will take place if their claims are dismissed and the claimants and their properties are returned to the domestic legal order of Costa Rica. I think that is a fair summary of the record before you, and I'll deal with some detail later. In short, if the claimant's claims are dismissed, they will be left to, and the phrase tender mercies occurs to me in this point, but they will be left to a domestic legal order in which the government has determined that their rights as guaranteed by customary and international law and the treaty will not be honored and discharged. By every measure with respect to liability, the state's actions in this case are in breach of the treaty guarantees and customary international law. In my opening, I said that there is not really a central debate about the existence of liability on that measure, that the central debate on the record should be about damages. And I maintain that because once jurisdiction has been established, the multitude of breaches is obvious and overwhelming. With respect to damages, I think a couple of things are of note. Firstly, the treaty guarantee is of, and I'm going to take it the most general, restitution in relation to the value of the properties. The explicit guarantee is fair market value, and we're all aware of how long and developed the evolution is to clear understandings of fair market value before the date of expropriation. But I start with the fundamental proposition that it is value and not cost that is an issue. And I'm going to come back to this in a moment, and I accept that in the absence of any probative evidence, a purchase price may be a proxy for value. And in relation to the questions which have been asked by the tribunal during the course of the week, Ms. Cohen will address the damages claim as articulated in the memorial, and will also respond to the questions in as specific a way as you can about any alternative based upon using purchase price as a proxy of value and what that would mean. To be clear, an award that was based on price as a loss is not consistent with the treaty guarantee. Using price as a proxy for value and then using appropriate measures to increase that value to the valuation date, and then adding to that a measure of interest from the valuation date to the date of the award, is at least in principle based upon value. Now, we're going to say, and of course we stand by our primary claim, that the only valuation evidence you have before you is Mr. Hedden's report, that you ought to give effect to that and use those values in your determination of fair market value under the treaty. That is your safe harbor as a tribunal, and you're assisted in this case because there is essentially no active professional debate about value in respect of the appropriate appraisal standards to be followed. What you have is a debate between a valuation expert and a damages expert who essentially has marshaled an argument in favor of price. Now, with respect to the period permitted to us this morning, I will be the principal person addressing you. I will address both the facts and liability. I will, in a summary way, address the jurisdiction and the answers to your questions. I expect that Dr. Weiler will correct me and or supplement my submissions with respect to jurisdiction, and I say both correct and supplement, and he'll be addressing some of the questions explicitly, and Ms. Cohen will be addressing both approaches to damages that we see active in the record. So that's who you'll be hearing from unless other people jump to the stand. So let me then try to start with some of the straightforward matters, and I'm afraid if I could have some kind of screen so I know what slide people are on. Okay. Yeah, that's good, just so that I know what other people are looking at. Thank you. We need a new English word for a surplus of screens, so that'll be maybe we can have a cash award for that term. And it will be recognized by the OED, I'm sure, within record time. So so I'm going to do some straightforward summing up now with respect to some of the questions you'll want to consider, and feel free to interrupt me, and I'll either answer, or if I can't, I'll defer and come back and provide you an answer later in the morning. So firstly, in general, and I think it is worthwhile as we go through the facts, and I'll do my best, and I've been thinking about this through most of the night, to try to assist you as best I can as to what are the factual questions and what's their relevance to the questions before you. This thing has been really fully briefed, but I've been trying to hone that to some degree as we go down, and as I go through this, I'll try to be of assistance to you, but of course, there are factual disputes, the resolution of which you don't have to worry about, as in every case. And there's some in this case that you don't have to worry about. The first one is, though, we do say that with respect to the knowledge of the claimants, which has been the subject matter of issue, placed in issue by the respondents and spoken to in the pleadings and the evidence this week, I say that your finding should be that it was reasonable for the claimants to conclude that the properties they were purchasing were outside of the park. And I say that is a sufficient finding of fact for you to proceed further. It is actually not a necessary finding of fact to proceed further, but it is certainly sufficient. And you don't need to go beyond that and put a fine point on it. You don't need to conclude that they were right, in my submission. And indeed, it's not necessary to conclude anything on that question in order to support the expropriation claim, because, to be explicit about it, the state has the right to expropriate the property, whether it lies inside the park or outside the park, that if it is private land within the park, as we know from the general evidence, it may be there for a very long time and the state has the right to expropriate it. But equally, if it lay outside the park and for public order or public purpose was needed to be expropriated, that's quite appropriate. So from the claimant's perspective, it's not necessary to establish that as a question of fact or law under Costa Rican law, but it is certainly sufficient for our purposes to say that the facts abundantly show it was reasonable to conclude the properties they were purchasing were outside of the park. Next slide, please. Now, as I said in my opening, this is a case about people and specific people, and the claimant's claims have factual differences between them that you will have to have regard to in respect of your consideration of the facts and as they rest on their separate claims for relief in this case. With respect to the Spence claimants, let me say firstly that the evidence is clear that there was no knowledge of a controversy in 2003 on the Spence claimants' parts, and that the purchase of the Ventanas lots in 2003 occurred, and there's a reference to the witness statement there. And there's this, the third point is that, of course, there were no stamps on the registry documents, and I've given you the references there. And finally, with respect to the Spence, and we'll come back to the significance of this, you'll recall that perhaps the most dramatic evidence of the skyrocketing prices during the material period was the sale of lot 35 for double the price in 2004. Now, could we turn? With respect to the Kofers and Holstons, you, of course, didn't hear from either of those claimants during the course of the week, but you have their witness statements. The Kofers had no knowledge of controversy surrounding park boundaries in 2003-2004. They purchased V39 and V40 in 2003, V38 in 2004, V46 and 47 in 2006. And the Menai stamps on the registry documents indicated those properties are outside the park. And I'm going to come back to the issue of stamps later, but that's the evidence as it relates to those claimants. Next slide, please. Now, with respect to Spence Co., and Bob Reddy was cross-examined and attended before you this week, it's clear that that Spence Co., through Mr. Reddy, performed extensive due diligence, and he did precisely what both Mr. Hedden and others indicated would be appropriate due diligence. He retained local counsel, he met with local real estate agents, he reviewed the property surveys, and that all supported a conclusion on his part that the properties were outside the park. Now, and I say that's a reasonable conclusion. Next slide, please. With respect to Mr. Berkowitz, who also testified before you this week, and there's some subtlety here to the evidence, and I may take a few minutes on this slide to indicate what I as counsel see coming out of the documentary and live testimony this week. But let me just review the slide firstly. I urge upon you a conclusion that he had a genuine belief that before completing the purchase of the B lots, you may want to make a note of that because he had an agreement to purchase them, but he, on the witness statement and the evidence, clearly deferred completing that purchase until he had concluded that the lots were outside the park. And his understanding of the law, and this is a purely lay understanding, was that he could build on the land until the government expropriated the land. It did not form part of the park. Now, if I can pause here and ask you to make a mental or physical note, you actually have ambiguity in the documents with respect to discussions about what's inside the park, outside the park, what is the park. And I'd commend to you the statement of Mr. Ruiz, which is part of the claimant's filing, which sets out the background law. Because it's clear as I read the witness statements that when we talk about the decree is actually not create a park. It creates a proposed park or decrees a proposed park. That under Costa Rican law, the creation of the park is actually not perfected or consolidated until the private land within the boundaries of the park has been paid for and expropriated. And so there are, if you will, in the loose sense, you can speak about lands that are within the boundary of the park that are not in the park because they haven't been purchased yet, but they're within the boundaries of the park and have clearly different risks associated with private lands within the park and outside the park. My next point, though, is I'd commend you to recall that in general within the country, vast stretches of parkland are privately owned today. This isn't a case where this park is unusual, and I'll give you the reference later when I turn up the slide, but let me stay with the point for a moment. The point is that with respect to the park policy, it is commonplace to decree a park or declare a park, but not to actually create the park under the park law, and for a very long period of time. And people enjoy their private rights, including construction, development, and otherwise, within the park in the meantime. I think one of the parks in the country has 90% private land, 40%, 60%. Those are the portions of private land within the boundaries of a park. And so it's not the case here that if you read the law, that the facts on the ground would marry what the law appears to be, that you declare a park, you buy all the land in the park, and then you have a park. Rather, the policy supported by the facts on the ground is you decree a park, you have boundaries in a park, and then you tolerate for indefinite periods of time people to exercise their private rights, including development rights, within the park. They're regulated, but they are clearly residences, such as the residences Mr. Berkowitz contemplated within the boundaries of the park, not only in this park, but in other parks in the country. And so the reason I dwell on this a bit is because I was looking overnight with some care at the evidence. And let me say this, and that is, I think it should be concluded as a question of fact that the minister provided a positive reassurance to Mr. Berkowitz that he could build his home on his property. That's the first thing. There's two ways to explain that. One of them being that it was related to a statement that the property lay outside the park in the sense of outside the boundaries of the park. Another way of understanding that would be that it lay within the park, but that his policy was to permit responsible low-density development within the park boundaries on private land. The July ayuda is completely consistent with the reassurance that construction and development on the part of Mr. Berkowitz could occur because the state did not want to incur financial responsibility for expropriation, and that it could occur within private land, either within or outside the boundaries of the park. He clearly understood that he could build and that his land was outside the boundaries of the park, but as council, it's open to you to find that the representation was, you can build on your property, you can do so responsibly, we don't want to take your property, but that's not inconsistent with it being within the boundaries of the park. And that would therefore reconcile the letters by the minister which were put in evidence, which are roughly contemporaneous in the spring, in which he positively averred in a formal sense to the 75 meters being within the park. So that's how I would deal with that narrow question of fact. Now, I think it is fair to say that there's abundant evidence of confusion. So one of the singular features of this is the June 2004 IGN study, in which it explicitly states that those properties are not part of the park, and I've given you the reference there. And the IGN is the National Cartographic Service, which, some 12 years later, is about to produce a map of the park. Okay, and I'm going to come back to our debate about coordinates in a moment. I can't avoid that because my father was a cartographer, but let me, let me say that for the present purposes, it's clear that there was a basis on which any reasonable person reviewing official documents could conclude that the properties are outside the park. And so you are dealing with, from the claimant's perspective, at its worst, a situation in which the state has, through its various organs, created a state of confusion. And I would say that confusion exists with respect to the 95 law, exists with respect to the 91 law. It exists for all the reasons the Contra la Ria report in 2010 says it is confusing and is not yet resolved. And I think I reread the evidence last night, and my reading the evidence is just a small point of difference between myself and counsel for the respondent. As I read the evidence, the map referred to in answer to the tribunal's comment is not the official map of the park yet. It is a draft that has not yet been approved as an official map, and that's why in the compliance chart it's seen as being ongoing. It's a small point, but it's not an insignificant point in that, assume for the moment we have an official map that is unpublished. That means that as of the date of this hearing, we still don't have a published official map of the park in any form, much less in a form that could allow us to see what was necessary to define its parameters. So just completing then, with respect to Mr. Berkowitz, I recall and ask you to recall that he purchased those lots in 2003, and we accept that the evidence is he paid $1.5 million for those. Minister Rodriguez, I've dealt with that. And of course, the second to final slide there is that he pursued in good faith the development of the lot, the building of his home, and then the indirect measures commenced with the rejection of permitting and the suspension of any development of his parcel, which has continued to the current day. So effectively, if I can summarize that, the indirect measures now have continued for 12 years with respect to preventing any exercise of his property rights on that parcel. The final bullet point there is simply to recall that one of the consequences, and it may be more legal than practical, but one of the consequences of defining the boundaries of the park is to exclude access to the beach area by the people who have the property, private property, located most closely to the beach. Go to the next slide, please. I'm just going to wrap up with the rest of the claimants and move on to a different topic, but I'll remind you, because the Gramillions didn't appear before you, we say that on the record they had no knowledge of controversy surrounding the park in 2004, which is when they purchased it. And you'll recall that Mr. Kaczmarek, and I'm tempted to say even Mr. Kaczmarek, but I say Mr. Kaczmarek agreed that Gramillion was unaware that Lot B7 would be within the park boundaries. Now, I don't want to spend an undue period of time on this. I think lawyers become curious about legal curiosities, and at the very least this is sort of, from a foreign lawyer's point of view, a legal curiosity. But I do want to at least address, to be of assistance to you, what I see the record and establishing with respect to the creation of the park. And of course, very quickly, it's I think forgotten by Mr. Rado in his opinion, but the first decree is not the 91 decree. The first decree is the wildlife refuge. So before the sun rises on the park idea, this has already been created as a wildlife refuge. And that is a degree, as Mr. Rado acknowledged in cross-examination, a degree of protection of the inalienable zone. The significance of that, if I can go back to the end, is simply from a lawyer's point of view. One of the bases of his reasoning was that Congress could not have intended the protection of the park to go seaward, because otherwise there would be no protection for the beach. That's both in his, effectively his oral evidence, as well as his opinion, and that ignored the preceding existence of a wildlife refuge decree and law. With respect to the 91 decree creating the park, there's a curiosity here, and I say a legal curiosity, and these are matters you don't have to resolve, but you'll recall that the 91 decree only extends to the southern part of the territorial area we've been dealing with, and yet when we go to the end of the constitutional courts, we see that the constitutional courts are looking at the power of the 91 decree to expropriate as a basis for finding that 75 meters should be expropriated by the relevant authorities, without an explanation of how the 91 decree, which was only on the southern half, conveyed any authority to expropriate the northern half, because the northern half is only encompassed within anything by reason of the 95 law. So there's an enduring curiosity with respect to the 91 use. I did reread, and it's not necessary for you to find this, but on my reading, as best I can as a foreign lawyer, it does not appear that the court decisions adopted, as Mr. Arado acknowledged, his reasoning about the 95 law. They just ended up at the same conclusion. And how is that relevant? Well, I think it's telling that the initial non-binding opinion and then the legal opinion of the Attorney General of the country ends up not being the means by which this land ends up being the subject matter of a mandatory order to expropriate. So that's a third legal curiosity that is of some legal historical significance. With respect to the opinion and dictamen, I don't have much to say about them other than to say that clearly the dictamen in 2005 represented us, and I acknowledge my friend's point that the dictamen in 2005 had a practical effect on the government. And of course, the Constitutional Court's decisions equally had a practical effects as well as legal effects. For the purposes of our position in advancing the claims, let me say this, and that is our interpretation of the evidence as a whole is that it's clear that the court in its final expression did not take on itself the responsibility and office of directing immediate expropriation. That the final expression of the court, and it's expressed in constitutional terms, is that to the extent we said that earlier, that's not our job, that's your job. Which for our purposes means that the state's decisions arising after the final expression by the Constitutional Court are the state's decisions within their sphere of authority. So it's not the case that the state's decisions in this case to suspend and to continue to paralyze the claimant's properties are connected to or in obedience of the Constitutional Court's decision. They had a choice, and they exercised and have continued to exercise and have renewed their exercise of choice since those decisions to continue to sterilize the claimant's properties and to continue to make them unavailable for any practical purposes. Next slide, please. So I think we all recognize the purpose of the park. Next slide. So these are really small points in the grand scheme of things, but let me say this with respect to the turtle population, because there was a debate in the pleadings with respect to what the principal causes of threats to the turtle population are. I just simply say to you, I think it's clear upon reading Mr. Piedra's testimony and Mr. Rusenka's testimony in the context of the record that historically in this area, the greatest cause of depredation was poaching, egg harvesting by people who, and I think one of the articles describes there being a commercial commercial business of taking all the eggs and taking them to the city and selling them. The fisheries in the post-park period clearly are the principal means by which adult turtles are being killed. And then climate change is a concern as it affects the conditions in the ocean. And then finally, development. The point being that if you're looking at hierarchies of care here, it is, I think, clear on the record that the claimant's proposed developments, it was not necessary to prevent them to preserve the turtles. Now, it's not necessary for you to find that, but I say that's a fair conclusion on the evidence. You may want to make a mental note there that in rereading the opinion of Mr. Arado in 2000 and earlier in the period, the one I just referred to, his official opinion, one of the comments I see is that he says that if there's no protection of the beaches in support of the 75 meters, then there's no protection of the turtles. There's really no recognition in his opinion at all of the distinction between protecting the beaches where the turtles nest and protecting the upland area. And of course, the discussions with Minister Rodriguez, the professional discussion and otherwise, hinges on the fact that the turtles do not nest above the inalienable zone, and that the area above the inalienable zone is fundamentally requiring regulation as part of what you would want to regulate going far further back. And so there's a legitimate government question as to how far, if you need to go back at all, and how much further you need to go back. But from a technical point of view, it's clear that it would be an entirely responsible position to take, that the upland property could be regulated consistent with the development in single homes and managed. And I don't think we've given we've given a reference to Mr. Rusenko here. I just thought it was actually a fairly dramatic example of what's possible, that he's managing a successful turtle preservation, conservation project in Boca Raton, which, forget first 1- and 2-story homes, Boca Raton is a highly developed, highly urbanized area. And we're not suggesting that was ever in the cards here, but the point is on the facts. What was driving the discussion around the 75 meters was not a nuanced or developed or considered assessment of the need to take the 75 meters. And in a sense, in my opening, I said to you on a fair reading of the record that you could reach the conclusion that the taking of the 75 meters is essentially an unnecessary and to some degree unwanted imposition on the state. And I support that because in my respectful submission, the most senior office of the state decided not to take the 75 meters, and the net legal processes which resulted in it flew in the face of that unanimous intention of Congress. And we're all lawyers here, and we can sort our way through to the various legal analyses which would see that happen. But from a purely factual point of view, what occurred in the final result was that legal interpretation of the law ended up operating to defeat the specific intentional desire of Congress to have the boundary of the park extend seaward and not inland. Next slide, please. With respect to Mr. Piedra, he was a passionate and as best I could read, both informed and careful advocate for the turtles. I think it's fair to conclude that he would like to have boundaries far more extensive than either 50 meters or 75 meters, and that he would like to have a control over areas beyond the park. With respect to the narrow question of his interview, it is difficult for me to reconcile his explanation for his statement with his statement. It's not necessary for you to conclude anything, but with respect, it's fairly clear that it may have been Mr. Piedra was speaking of the park in the same practical way that the minister was, which is we don't have a park that includes 75 meters because we haven't taken those lands. And so he, as the administrator, is saying what we have is 50 meters and 11 miles of territory. However, it goes far from saying and supporting his conclusion, and we answered this, which is his witness statement says, everyone always knew it included 75 meters. And that's an assertion that can't be supported on the record. Next. So just a reminder that the lobbying for protection went before the 91 decree and included the Tamarindo Wildlife Refuge. Next slide, please. They, sorry, okay, that's good. And this is just a reminder of what the Tamarindo Refuge shows and the protection of the beach. Go ahead. With respect to the 91 decree, and this was the point I was trying to make, and again, I'm perhaps drawn by my enthusiasm for cartography, perhaps wrongly, to this point, as it's not a necessary point for the claimants. But the point in essence is the 91 decree and the 95 decree were not cartographic representations of an area. They had a northern point and a southern point. And on the whole of the evidence, I think you can conclude that any cartographer with that description would actually need to describe 4 points, none of which were described in the 91 law or the 95 law, because the western points would be described by reference to high tide, and the eastern points would be described by reference to a line from high tide. Neither the northern point, the southern point in either law were so fixed. That's my point. So what they do actually provide is a northern extent, a southern extent, each of them change. The idea that somehow they dictated a boundary of the park is not correct. Next point. With respect to the, I think we can go back a slide. I think I can slip that. Okay, I've said that. Let's keep going. Now, the 95 park, I think I've said all I need to say about that. I would say that in the documentation and in the pleadings, to some extent, there is and to some extent the history of the question. One of the issues is, if there isn't a 75-meter zone, why is there a reference to private property within the park? Because if there isn't that terrestrial component, why are there references to taking private property? And the short answer is, on either reading, and Mr. Hirado agreed with this, there's lots of private property within the park, even if the 75 meters does not form part of the boundaries. There's an entire area of Cerro El Moro and Isla Verde, and I don't know if you recall this, but Isla Verde is not an island. It's essentially a large inland wetland area. It seems to be a wetland area, and of course, Cerro El Moro is a large area in the northern part. Next slide, please. This is just a reminder of the point of that under the park law, owners enjoy the full attributes of ownership until the expropriation process is commenced, and that is, as I said earlier, a general fact on the ground in the country as it relates to parks generally. Next point. I think you've got this, but this is just my reminder of how explicit and unanimous the decision to move the boundary of the park offshore was. Next slide. And then, that's fine, let's go to the next one. And I will say this, and that is, sorry, if you go back a slide. As I read the translation, and I apologize for not being able to read the original Spanish, that implicit in the motion was the principle that what was needed was a marine park and not a terrestrial park. And I say that as in respect of it meets the requirements of a law of this type to protect parks, especially it should have been marine. And I see that as referring to Deputy Fournier's comment about the 91 dimensions, that they in fact shouldn't have been landward. They should have been marine, so that he knew he was changing what had happened in 91, and that the justification for it was because what was needed was a marine and beach, and he specifically talks about ordinary high tide there. So that is unanimously agreed to by Congress. Obviously, their effort to accomplish that by way of the amendment was ultimately unsuccessful. Next slide. I don't think we drew this to your attention in the opening, but the corroboration for the fact that it was not a casual conclusion is in his letter of January 5th, 2007, in which he says there was no environmental justification whatsoever for going beyond the 50-meter strip. Next slide. And so I say as a fact, you should have regard to the fact that Congress's decision was intentional and not a typographical error or a casual textual mistake. So I don't think the final point on this would be, and this was supported by the Contraloria's report, in which the distinction between territorial waters and internal waters is another source of uncertainty in description of the boundaries of the park. Next. And then I think we've done that. So let me just pause there and say, I do want to say that you can find, I think, that the boundaries, as a matter of fact, that the boundaries of the park were not adequately defined in the 1991 law or the 1995 law, and through omission, they have not up until, in any relevant sense, up until the present, been adequately defined. And the significance of that, of course, is as the backdrop to investors investing in lands adjacent to the park, the absence of state action to carry out what their laws require, which is a clear definition of the law, because the whole point of the Contraloria's point is the law wasn't, this precise boundaries are not really intended to be defined by the description in Section 1 of the 91 or 95 law. Further work's required for that. Further work was required in any event, and further work has now had to be carried out to carry that out. So that failing ought not to be visited upon the claimants. Now, that is just a reminder, if you go back to the slide, please, thank you, that, and I think, as in many civil jurisdictions, Congress is the ultimate interpreter of the law. We often in common law jurisdictions don't think that, because we're more fond perhaps of the judicial function, but it was totally legitimate to seek to have Congress clarify the matter, and there were efforts to do that, both to clarify it as going inland and to clarify it as going seaward, neither of which, as I understand the records, succeeded. And until the Constitutional Court clarified the matter, it was clear that that was afoot, and from a practical point of view, the Congress ultimately was the appropriate body to clarify its intentions when it clearly had acted on a specific intention in 1995. That wasn't done, and then ultimately it was left to the court, which happens in not a few cases around the world. The final bill, of course, was an attempt to again go to Congress and say the net result of the court's decisions is that your intentions have been frustrated and you have not had a congressional decision, an informed congressional decision on the very question of whether the 75 meters ought to be protected in addition to the 50 meters. And just to remind you that the bill which was on place and being debated after January 2009 was seeking not to remove protection from the turtles, but to rather have a mixed refuge and to rectify the limits of the park. And there's a typo there. It should say lapsed and archived in 2013. I think that's a typo from the original slide. Next slide, please. So I think I'll speed up here a little bit, but just to remind you, we didn't deal with this in the opening specifically, but just to remind you that the Constitutional Court decision, the first one in May, was this conflict between zoning regulations. And I remind you in the pleading, we've brought your attention to the fact that another official source of confusion is that the municipality exercised and purported to exercise zoning authority over these lands. And so ultimately, one of the consequences of the Constitutional Court decisions was that those zoning provisions were found to be invalid or ineffective. Next one. And then, of course, you'll recall that there was a decision which on any reading appears to have ordered an immediate expropriation or a decision to encourage environmentally sensitive development and then continue. And then we're actually missing the point, which is the December 2008 one, but I'll just remind you that was on, I think, any fair reading, appeared to be an immediate order to expropriate. And then when we get to the spring of 2009, it's back to the administration to decide. Next slide. Now, with respect to the Contra Luria report, which I'll have much to say later in our submissions, this is a summary. First of all, it's quite harshly critical of all of the boundaries in the 1995 law, and I think that is justified. Secondly, it's harshly critical of delays in the conduct of expropriation, and that again is clearly justified. The next point is a point of some significance, is that on the record you should conclude in my submission that what the Contra Luria report recommended was a short suspension, that is a matter of months, pending a determination by the responsible agency whether to seek annulment. And I'll try to give you the specific pinpoint reference later, but Mr. Jurado admitted that. And the concept there, and I think I have a slide coming up, but just the concept there was you have to decide whether to take the next step, which is to actually annul all the claimant's properties, and it is general, and there's no question that if you look at the text, there's actually explicit reference to the source of the claimant's properties, but it's also more general than that. But the point is, in respect of due order, is that Contra Luria said, this is a significant step. You have to decide whether you're going to do that and report back to us in the spring. Spring 5 years ago. Just the decision of whether to do it was the spring of 5 years ago. That, on the pleadings, was justified as the suspension which is still ongoing. And what I say you ought to find as a finding of fact is that Contra Luria did not recommend an indefinite suspension. I'm going to come back to what you ought to conclude, but what you ought to conclude is that the responsible agency and the government of Costa Rica as a whole intervened to use the Contra Luria report as support for a more general, indefinite suspension, which is ongoing, and which intervened in the historical period as a fresh decision that is within the treaty period and within the limitation period, and is ongoing. The reference I promised you is apparently transcript day 3, page 602 to 604, Mr. Jurado's testimony. Now, I haven't finished yet with that slide. I say that you ought to find as a fact that the deadlines for decision and action within the Contraloria report appear to have been ignored by the responsible agencies. I say you ought to conclude, as I mentioned earlier, that the official map project based on the compliance document and the report is ongoing and unpublished. And most remarkably, in respect of the evidence this week, that the consideration of annulment on the record by the responsible agency will start after an external report, which has not yet been received, will be received sometime in the indefinite future. And I want to pause here and say that is, with respect, the most remarkable chapter of evidence in this unhappy history for the claimants to be present in this hearing and to learn that their properties will be the subject of some future decision about annulment that has not been made 5 years after it was recommended to be made, and that for Mr. Jurado to say the decision-making process will start after an external advisor, apparently, we don't know who it is or what it is or anything, will report back sometime in the future, which he hopes to have happen by the end of the year, but he can't promise anything. That is a remarkable renewal of and promise that this is not an ancient matter. This is a fresh and ongoing dispute between the parties. And it's the most clear evidence, corroborative and supportive of the state's determination to take the claimant's properties and to do so either with no compensation if achievable or as late as possible and not in accordance with their obligations under the treaty. Next slide, please. I've given you the references there in summary of that submission, and I think that those are helpful to you. Next slide, please. Now, that's a small, for our purposes, a small point because the manual expropriation clearly isn't dealing with the annulment or legal process, but it is helpful, I think, to as a context of you deciding liability, and this is one of many, many points of light, if I can put it that way, the absence of a manual for expropriation internally within the agency is supportive of our fundamental position, which is that the state has not discharged its obligation to proceed to expropriation. It's determined upon without delay. Next. With respect to the land registry drawings, I think that with respect to relevant matters, I've dealt with them, but I've said, for example, we have these stamps, there are no stamps or stamps saying outside the park. With respect to the 1991 stamps, you have the evidence that those were reviewed, so it's not the case that they were missed. Legal opinions were given with respect to the significance of stamps, which refer to the 1991 decree, and they were explained as not being inconsistent with the lands being outside the park. And that's the kind of due diligence you would expect, and it supports the reasonableness of the claimant's conclusions. With respect to the 1995 stamps, they appear to have been added after the, if you will, fresh determination by the Attorney General that that's what was required. And so those are not indicative of an official indication of the boundaries of the park under the 95 law at the relevant time period. Next stamp, please. And that's a summary of what I've said, and Ms. Chavez, in her testimony, eventually came to admit as much. Next stamp, slide. Now, as part of the context of delay, of course, you'll recall Ms. Chavez, or Dr. Chavez, I apologize, acknowledging that under her carriage, the state has been appealing and deferring finality, and it has actually been seeking to change dates of dispossession, and as she acknowledged, dispossession under Costa Rican law is not the final step of the expropriation process, and that is the transfer of title. If you want to make a note, the ILC concept of expropriation is the same, which is that the actual act of expropriation is a transfer of title. And if I can flag for you, and I'll come back to it in a moment, that with respect to indirect expropriation, the notion of indirect expropriation is simply to acknowledge the need for a remedy where the state does not acknowledge that that's what's going on. And the remedy provided, as the respondent in this case asks for, is to conclude the expropriation in the normal form in an indirect setting because the award is conditioned upon a transfer of title. So there is a significant difference between the two, because where a state does not acknowledge that its actions are indeed a process of expropriation, but they legally constitute acts which are tantamount to expropriation, the end point of the exercise is the same. The end point is that that act of expropriation is completed, finalized legally on the transfer of title after the rendering of the award.
Mr. Coper, may I just ask a point of clarification? You say the ILC concept of expropriation. Can you just clarify what you mean by the ILC concept of expropriation?
Well, sorry, it's the ILC reference. I'll take you the specific reference, but Judge Schwabel's opinion quotes the ILC, and I'll get the specific reference, but and it essentially says expropriation is the transfer of title.
I just want to be sure whether you're talking about the International Law Commission's articles on state responsibility, which deal with restitution, the consequences of a wrongful act, or whether you're talking about some other document. So if you could...
I'm referring to the definition that's quoted, and I'll get the specific reference. I apologize if I misreferred to it, but I think it's in the context, but it's in Judge Schwabel's opinion. My point is that, and let me urge upon you the conclusion, that I'll give you citations, that fundamentally in international law and in domestic regimes, there actually is a remarkable consistency of treatment, which is that taking of real property by the state is accomplished by the transfer of title from the individual to the state. That direct expropriation, where the state acknowledges that is its purpose, is taken when the title is transferred and paid for. And there's some variation as to whether payment happens or title happens, because some states are transfer title and then undertake the obligation to pay. So other states pay first as a condition of title. In respect of indirect expropriations, where the state denies that it is seeking title, the state in an indirect expropriation is exercising state power, which has the effect of taking the property, but is not acknowledged to be a taking. But the end result of that is that the measures which are tantamount to expropriation conclude with a legal conclusion that there has in effect been a taking, and the appropriate legal response under international law and in this treaty is that the state has to discharge its obligations as if it had determined on an expropriation, and its right to have the title is acknowledged as part of that. Next step, please. Okay, now, just because my friends are trying to help me as I go, so I'll give you a reference to that, and I'll come back to it if it's wrong. It's footnote 17 on Judge Schwabel's opinion. It's the ILC articles on state responsibility. And I have a note here, but RLA-5. That's right.
May I just clarify that's a reference to Crawford's commentaries on the ILC articles, not the ILC articles themselves.
Thank you. So apart from my citation, though, I think I'm standing on submission I made with respect to the concept of expropriation under international law and domestic law. Next slide, please. And this is, we're getting to, I think, an important point that you'll need to consider. And to some extent, this is freshly plowed ground, so I want to go a little bit slower. But in reviewing the record and the pleading, there seem to be three categories of investment in relation to the totality of measures that you have before you. The first, of course, is you have lots that are awaiting a valid decree of public interest, followed by a decree of expropriation. You can express those in a different way, but that's the first category. And the second ones are those which are in the judicial phase. And the third are those in which there has been a final determination of compensation has been given, and whether or not it's actually reached this stage, the final transfer has not yet to occur. Next stage, please. I would say all of those are properties that are directly or indirectly under a process of expropriation that has not been completed. With respect to the first lots, I remind you that Costa Rica's position in this proceeding has been unequivocal, and that is it will complete the consolidation by expropriating all remaining private lots, all of the claimant's properties that have not yet been expropriated. And its basis for doing so in the pleading has been compliance with the Constitutional Court, and you have my submissions as to whether that is true or not. I say you ought to find as a fact that it's an independent decision by administrators rather than a mandatory order from the Constitutional Court, but it's a point of detail. To be obvious about it, it doesn't matter for purposes of our case whether it's one or the other. The further expropriations are imminent, as I've said earlier, because of the recommendation relating to annulment. And in fact, as we said, the court lifted the immediacy requirement in its March 2009. I think that should be decision, not letter, but I stand to be corrected. And then secondly, the 3-month delay I've talked about, and at some point after May of 2010, a decision or decisions have been made to maintain the suspension. On new and somewhat undisclosed grounds. Next. Now, with respect to continuing this category, the new delay measure, and it truly is new if you look at the historical record here, is within the treaty period and was only known to the claimants during the course of this arbitration. And so no jurisdictional objection can apply. Now, if you're to find and you feel you need to consider what the conclusion on the facts is on a balance of probabilities, I think you can safely conclude that that measure is intended to be of indefinite duration, save for the possibility that title to the properties could be annulled, which would then obviate the need for any compensation. The third slide, no, sorry, go back a slide, third bullet point, sorry. And Costa Rica, in our submission, has admitted that its measure has had the intended effect of delaying commencement of the formal or recommencement of the formal expropriation process. And there, in our submission, that measure is prima facie inconsistent with the obligations under 1C or 2A of Article 10.7. And I'll foreshadow an answer to one of Mr. President's, your questions, which is we say in principle that with respect to the specifics here, that there is and you use the word freestanding and independent, whether I would do that or not, there is a separate treaty obligation that is evidenced in both 10.7 and 10.72 in relation to delay. And the point in principle that I would make is that if an expropriation has been commenced with due order for a proper public purpose, and fair market value has not only been established but has been declared, and that's all in due order and appropriate, and then for whatever reason the state then engages in an undue delay because it doesn't want to pay for one reason or another, then those acts of delay are in breach of that obligation under the treaty. And they're separate breaches of those obligations, and it's knowledge of those breaches which is at issue with respect to the running of the time bars. So that, I'll come back and I'm going to answer your questions later, but that's the short answer to, I think, your first question, or part of your first question. With respect to 10.5, and I said in our opening it's a secondary consideration, but I will say this, and that is, I think the remarkable situation the claimants have been left in for the last 5 years, arising out of the Contra Rica report, are the type of arbitrary state measure against an investor that are contemplated as being prohibited by the FET standard, separately from the expropriation concepts entirely. I think it is a fair conclusion to say that those facts justify a conclusion that there has been a breach of the FET standard, and if that's a relevant matter for you to consider, you ought to be able to conclude that on those facts. And to foreshadow a little bit, the net conclusion of that is you still at the end have the same appropriate measure of damage for that breach, because ultimately what you need to do is to make the claimants whole for that breach, which requires an award giving them the value they ought to have been granted, plus a measure for the time bar. And I've said that in a sense, and you can say it a number of different ways, but under either theory of liability, the deprivation is total, and thus the valuation and the damages ought to be, whether you call them compensation or damages, ought to be the same for both. Next slide, please. Now, moving to the second category, and these are the ones in the judicial phase, and I recall that the delay in this case in respect to the judicial phase is very lengthy by itself, and we commend to you the comparison with the conclusion of the 4-year delay in the IO European case. And we say that the delays experienced by the claimants in the judicial phase, this category, are inconsistent with 10.7, as I say, because the delay constitutes a self-standing and independently actionable breach of the promptness standard, the prohibition of being, the promise to compensate without delay, and the concurrent, if you will, or related denial of justice associated with arbitrary measures under 10.5. With respect to the again, the theory of liability for each of those breaches concerns evidence of Costa Rica's conduct after the treaty came into force. That is the controleur and the response to it. Next phase. With respect to the, pardon? Yeah. With respect to the, just continuing, with respect to Article 10.18, of course, there's an objective test for knowledge of breach, and I've already foreshadowed that. The appropriate question is at what point a reasonable investor would have been expected to conclude that the delays he or she had endured since the treaty came into force should be regarded as a repudiation of Costa Rica's treaty promises. And by that measure, objectively, there can be no objection by reason of time bar. And then with respect to 10.7, I don't think I need to read the next bullet point. You can read that. Next slide, please. So then moving to the third small handful of lots for which a final determination has been rendered, they've all suffered from the same problem, which is the compensation offered by Costa Rica has not been consistent with the fair market value for each. And with respect to the failure to provide investors with compensation values equal to fair market value, that's inconsistent with the standard under the treaty and the fair market value standard guaranteed by 2B. And the point there, of course, is that with respect to those measures, they are concerned with facts arising in respect to the breach that occur within the treaty period. And you'll recall, and there are various forms of looking at this, but if we take an example which is contrary to the example I gave earlier, and you have an example where the taking is for a bona fide and legitimate public purpose, and that it purports to be pursuant to a process like this offering fair value, and that there is then a determination some years later of the actual amount under the standard, but that on the evidence it's clearly that there's a breach and that fair market value was not extended by the state. That's a breach that occurs at that time. And any consideration of a time bar has to relate to the fact that that can't be known until that time, in that circumstance. And it may be useful, and I'm sure I'll be corrected if it's not useful, to say that there are many different circumstances which will justify different conclusions as to when it's fair to start the time potentially. And so a taking in which there's a round rejection of any obligation whatsoever and a taking of the actual title, so that there's nothing further to be done, and from the state's perspective, may justify a different conclusion. Those aren't the facts here. But you can imagine different scenarios, and the ultimate submission I make to you is that the principles under the treaty, the principles under the law have to be married to the circumstances. In this case, I would urge you not to try to solve all of the timing issues with respect to all the potential cases that may arise out of both direct and indirect expropriation circumstances. Next slide. And I think this slide essentially makes the point that I've just made. So I think I'm going to suggest we have one coffee break. I think I've gone for an hour and a quarter. If we want to take the break now, and then I'll come back and we'll...
That's fine. Let's take a break now until 11 o'clock.